to the Miller Center's forum on today's topic of the U.S. Supreme Court. I'm Barbara Perry. I'm the Gerald L. Beliles Professor and Presidential Studies Director at the Miller Center, where I also co-chair with Russell Riley the Presidential Oral History Program. Today we have two experts with us. I will introduce them shortly, and we are going to be talking about the U.S. Supreme Court's current cases, that is cases before it this term, which starts every year, the first Monday in October, and runs, generally speaking, through June. We're going to talk about its public image. We're going to chat about Justice Breyer's recent announcement of his retirement and potential replacements for him. We also want to talk just a little bit, too, about President Biden's lower federal court appointments. And of course, we want to take your audience questions. And let me say, you don't have to wait till the end of the hour to pose your questions. If you will put them in the Q&A function on Zoom, we probably won't be able to get to all of them, but please start posting them now if you wish, and we will attempt to intersperse them in the terms of our discussion as well. I want to have a special welcome for our governing council who met this morning in their winter meeting for the Miller Center, led by Steve Burns. Without you, we wouldn't be able to do these programs without your support. So we thank you for that, and we hope that you enjoy our program today and will participate by offering your questions. Also, of course, want to thank Christina Lopez-Guattari-Chow, who is a professor at the Miller Center and director of the forums, to our colleague Alfred Reeves IV, who is one of our faculty and program coordinators, who did a lot of research for our program today. Always thank our IT team led by Mike Greco, communications team led by Howard Witt. Again, without you all, we could not produce these programs. We also could not have two more experienced or knowledgeable colleagues today to discuss this topic of the U.S. Supreme Court, and we're happy and honored to say that both Sarah Wilson and Sai Prakash are fellows at the Miller Center. Sarah is also a partner with the renowned law firm of Covington in Washington, D.C., and she and I served as Supreme Court fellows in 1994-95, so we have been now longtime colleagues and friends with that friendship and collegial relationship around the U.S. Supreme Court going back, well, perhaps a few more years than we now like to admit. Sai Prakash, another friend and colleague here at the university, is a chaired professor at the University of Virginia Law School. He served as a law clerk at the U.S. Supreme Court to Justice Clarence Thomas. Sarah and Sai have also served as law clerks at the lower federal court levels, the U.S. District Court, the Courts of Appeals. So they have experience throughout all three tiers of the U.S. federal court system. And in Sarah's case, she served as an Article I judge during the Clinton administration. At some point, we'll talk a little bit about what are Article I judges and how do they differ from what we call Article III judges, because we're going to focus mostly on that today. But for you in the audience, we'd like your participation right off the bat. It is the case that going back to the 1970s, the Gallup poll organization has been asking the question of a representative sample of Americans, do you approve or disapprove of the way the U.S. Supreme Court is handling its job? And most of us are used to seeing approval ratings about presidents and sometimes of Congress, but sometimes we're less used to seeing this about the U.S. Supreme Court. So we're going to have this posted. You will see this if you are in the audience today. Please answer the polling question. Do you approve or disapprove of how the U.S. Supreme Court is handling its job? You will see an option to approve, an option to disapprove. And soon we will get those statistics to you, and we will chat about the possibility of how our audience today might be the same as the representative sample of the American people, or it might be different. So we'll look forward to seeing that. This is a particular interest to me because going back to the 1990s when Sarah and I had our fellowship at the court, we were very interested in the issue of public image of the court. So I'm getting now from our colleagues what our poll rating said. 26% of our audience approve and 73% disapprove. Interestingly, for the representative sample of the American people polled by the Gallup organization, that has been at a disapproval rating for the court of about 40%. So our audience is a bit higher than that at 73% today. And as I was saying, back in the 90s, there were some controversies surrounding the court at that time. One had to do with Justice Thurgood Marshall having left the court, gone into retirement in the early 1990s, in fact, replaced by Cy's mentor and boss, the Judge Justice he clerked for, Clarence Thomas. And when that happened, only within 1 year, Justice Thurgood Marshall passed away. And he had asked that his papers be released by the Library of Congress as soon as he passed away. And there was some controversy at the court because it's confidential and it's conversations behind the scenes. And so there was some concern that there would be confidential material in those materials that were released. In another situation at the same time, the Library of Congress, the archives, particularly the National Archives, had all of the oral argument recordings that had started being recorded in the 1950s. And you could go to the National Archives and listen to them, but there was really no other way to hear those. And a professor went and recorded those, saying he was going to use them for scholarly purposes, but then he compiled them into a book and released them as written transcripts as well as the recordings. And so he had violated the actual agreement that he had signed with the archives to use them in the classroom simply for scholarly and teaching purposes, not to release them and publish them. So there was some controversy over that. So I put this to Cy and Sarah. All three of us have worked at the Supreme Court. I think it's not too strong to say we love the court as an institution. And so we care about how people view it. So what are your thoughts when you see our audience poll today, as well as knowing that this 40% disapproval rate among the, or let me put it oppositely, the approval rate of the court is down now to 40%. And people have been commenting on that in the national media because it's one of the lowest disapproval or approval ratings that the court has had over these many years that these have been taken. So I throw that out to both of you and want to know your thoughts about it.
Well, I'll start. I am finding that disapproval rating to be alarming. While I think it's certainly the case that both Supreme Court decisions as well as Supreme Court nominations have been contentious since the beginning of American history. It does seem as if we're in a precarious time, if not an unprecedented time. Just by way of example, on the uptick in polarization on the nomination process, the Democrats invoked the nuclear option for lower court nominees. The Republicans did that for the Supreme Court. With the blocking of Merrick Garland's, the allegations around Brett Kavanaugh's confirmation, and the hurried confirmation of Amy Coney Barrett to replace Ruth Bader Ginsburg, I think the public has been exposed to a more heightened period recently, is sort of a compressed and highly politicized period on the nomination and confirmation point. On the positive side, I'd sort of forgotten, Barbara, about those controversies from the 90s. They seem almost quaint. I will remember the debate that the Judicial Conference had over whether to televise court proceedings. And as fellows, we were lucky enough to be able to attend those Judicial Conference discussions. And I remember leaving thinking, forget about televising courtroom proceedings. Let's talk about televising these Judicial Conference discussions, these policy discussions.
Sarah, you might say a word about what is the Judicial Conference?
The Judicial Conference is the policy, the governance body for the federal court system. So it is the organizing body for discussions about potential reform of civil and criminal rules, as well as taking up issues that will affect courts across the federal judiciary, like televised courtroom proceedings.
So but now the Supreme Court still doesn't allow TV, as we know, does not allow TV cameras. It is much more open now about allowing the audio sometimes in real time as it has this term, or it sort of warmed up to that by having the audio released just after important cases would be argued. So they are opening up to that slowly but surely. But we should also state that when we were there in the mid-90s and this was being discussed behind closed doors by the Judicial Conference led by the Chief Justice, with all of the Chief Justices of all the circuit courts and then representatives from the district courts, as you say, in this policy-making governance body. But we were there just 2 years after the O.J. Simpson trial was televised, as people might remember. And I think that certainly put a bit of a pall on whether the court wanted to. But let me turn to Cy and ask your thoughts about these polls. Do you pay attention to them? Do they concern you? Is there anything the court should do or could do about them?
I could see why people would be concerned. I guess I don't pay attention to the polls. I didn't know the figures that you were quoting, Barbara, so it's interesting to hear. I think it's understandable that people are upset with the court. Some people are upset with the court because of the way that Donald Trump got 3 appointments. Other people are upset with the court because of what they might do this term and beyond with the new Republican majority. And then I think there are some people that take cues from their political leaders, and there's a good segment of the Democratic Party that wants to refashion the court by adding justices, or wants to sharply criticize the court for various reasons to delegitimize it. And those have effects, right? So if you go back and think about impeaching Donald Trump, which is a totally unrelated question, I think a majority of Democrats were opposed to it until Nancy Pelosi said she was going to do it. And then people's views on that as Democrats changed. So it's significant that I think one political party, for good or bad reasons, has chosen to attack the court. And that will obviously have consequences downstream with public opinion.
Right. And it's also interesting to note the polarization that can occur. So after Bush v. Gore in 2000, which was one of the most polarizing elections up until recent elections, and certainly a polarized decision for the court. And when the Gallup poll organization took this same poll, I think it was 90% of Republicans said they approved of the job the court was doing, and only 30% of Democrats. So again, a polarization. But when you average those, the court came out with a rating of 60% approval rating. So this approval rating now of only 40% is what has some people concerned, as well as going back to the founders who noted, Alexander Hamilton said in the Federalist Papers, the court does not have the power of the purse or the power of the sword. And so many people, I think, correctly argue that it's the moral suasion of the court. It's persuasive ability and the discussing and deciding about the rule of law that gives its authority. And so some people worry about that as well. So let's move on then to cases, as we've promised for this session. We already have a couple of questions that are coming in, and we'll circle to those. What are your thoughts, can I turn to you, Cy, about this case that has, of course, gotten so much attention on the right and the left, the abortion case that's coming through from Mississippi, that is asking the question, does Mississippi's law banning nearly all abortions after 15 weeks of gestational age, is that unconstitutional? And if you could sort of put that into the context of precedent and how the court may decide on that.
Sure. And I think you're right, Barbara. That is probably the biggest blockbuster case of the year and maybe of the decade. As many people know, the court in Roe versus Wade concluded that the Constitution protected the right of women to have an abortion. But it was a qualified right, and it varied over the course of the pregnancy. And that decision triggered a political backlash that led to the appointment of several Republican justices. Many people thought those Republican justices would overturn Roe versus Wade, but in a case called Casey, the court didn't uphold Roe versus Wade. It didn't overturn it. It modified it. It kept parts of it and rejected others, but in a way that left Republicans deeply unsatisfied, pro-life people deeply unsatisfied, and pro-choice people somewhat unsatisfied. It's better than having the case entirely overturned, but not as good as keeping it intact. And the court in that case suggested that it couldn't overturn Roe under fire. It shouldn't be perceived as doing so. And of course, pro-choice folks liked that discussion. But, pro-life people looked at the opinion and thought, well, you're choosing not to reverse under fire, right? That you're worried about the perception of you that will result if you overturn the case. And what's changed is that Donald Trump named 3 more Republican appointees, and his Republican appointees are to the right of even the Republican appointees they replaced. Right, the elimination of the filibuster by Harry Reid led to more extreme judges on the right and the left, and so Donald Trump got very, very conservative people through. Joe Biden will get very, very liberal people through, at least until the Senate perhaps changes hands. But I think most observers looking at this case believe that the court is either going to pare back Casey or overturn it. And I would bet overturning it.
Sarah, we have a question from one of our listeners and watchers today, Jim Webster, sort of asking about this general topic. And since you have served as a judge yourself in the federal system, he's asking, how do you interpret the trends in the decisions of the court to reverse decisions or issues which seem to have been solid up until now? And this obviously relates to things like Roe and the Casey case. Your thoughts?
Well, I think how the court contends with stare decisis and whether to overrule a precedent is really central to this question of the court's legitimacy and perhaps this declining approval rating. I agree with Cy's observations. Neither Roe nor Casey took an absolutist view on the legality of abortions. Roe had this trimester fetal viability framework, which is a tough one for courts because it involves scientific questions that they're not so well equipped to resolve. Remember the stories of Justice Blackmun spending the summer at the Mayo Clinic trying to figure out when a fetus is viable. Casey replaced that with the undue burden test, which I do think is a more comfortable type of balancing inquiry for courts to deal with. But I just want to read the full quote in Casey. Roe was decided by a 7-2 majority, and then 3 Republican appointed justices went out of their way to reaffirm the precedent in Casey, saying, so to overrule under fire in the absence of the most compelling reason to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question. So scroll forward, we heard Justice Sotomayor asking really her colleagues, I think, can the court survive the political stench, as she called it, very, very heated terminology, of potentially overruling such a important precedent?
Well, before we went live, we were talking about a case that dealt also with, as it turns out, a hot button issue and also a public health issue, and that is the vaccine requirement. And so the question that came to the court that it decided very recently was, does the federal government, particularly the Biden administration, have the authority under OSHA to mandate vaccine or testing for large employers? We're seeing now in Canada the issues as they relate to government mandates for vaccination. But Sarah, you want to jump in on this because I thought you had a very balanced view as we were discussing it before Cy joined us in the green room of how you viewed this particular set of opinions, both the majority and the dissenting opinions.
Sure. So as someone who practices in the area of administrative law, I paid close attention to the court's interpretation of the authority of administrative agencies. And the court's conservative majority is showing more and more that they will not let agencies assume greater authority than Congress has clearly given them, even in this case, in the face of a unprecedented pandemic. And particularly on what are known as major questions. The court is increasingly drawing on this major questions doctrine where it says Congress has to clearly state in a statute what an agency's authority has. I found myself being fascinated by the fact that both the majority and the joint dissents in the OSHA case said who decides. It boiled down to who decides. The majority saying it's Congress through clear prescriptive language, and if you don't have that clear language, then an agency can't overreach. And the joint dissent saying that it's risky for a court, and I believe the dissent uses the terminology by judicial diktat, again, very strong terminology, that it's the agency and the president who is politically accountable to the people, that is that expert agency that should make a decision. I think another thing that struck me about the majority decision, well reasoned, but I felt what was missing was some evidence of real practical understanding of the challenges posed by this pandemic, particularly for most American workers who work in close confines. Think about the surges in the meatpacking plants that we had in the early days of the pandemic. These are justices that work in chambers that I don't think it's a little bit of an exaggeration to say that they're the size of small football fields, but easy to social distance, requiring litigants and their counsel to be masked and vaccinated, and yet, declaring that OSHA, the expert agency, doesn't have the power because it's not a workplace hazard, and that one can contract COVID just as easily as a sporting event or a movie theater as in a workplace. And to me, I felt that was sort of a little bit tone deaf.
And we should point out they were doing oral arguments online. So, Sai, thoughts about that decision?
I thought it was a difficult case. I agree with much of what Sarah said. I think the majority's opinion is more nuanced than people might suppose. The court actually said if you're working with the coronavirus, they can create rules for you. And they actually said also, if you're working in close proximity to someone, they can create rules for you. The problem is that they applied this to situations where people weren't working in close proximity. They applied it to landscapers and people that are outside all the time and people who aren't in close. So it was the breadth of the rule, I think, that caused the problem for OSHA. If the rule had been tailored to employee workplaces where people are cheek to jowl, the court signaled that would be fine. I think, having said that, I don't think either the majority or the dissent had a coherent or fully fleshed out understanding of the statute. If the dissent is right, I think what's to prevent OSHA from requiring workers to have their spouses and children vaccinated on the theory that if they're not vaccinated, they're more likely to pass on the virus to the workers who will then pass it on at work. I think the problem with the broadest reading of the statute is you can regulate coughs and colds and all kinds of other diseases that you might bring to the workplace in a way that's never been done before. So, I think Sarah's right that there's like a point to both sides, but they don't really tell us what are the limits of what OSHA can do. Neither the majority nor the dissent tell us, why they're right, I think, ultimately.
And thank you for that, Sai. We should point out to our audience today, Sai, in addition to being an expert on constitutional law, as is Sarah, is also interested in presidential and executive branch power and has written books on that subject, which we recommend to you. One is called Imperial from the Beginning, about how powerful our executive branch and certainly presidents were, even before there was much of an executive branch to write home about. People often talk about the hot button culture war issues as being related to God and guns. And we actually have two cases one involving religion and one involving guns before the court, as it so happens this go round. The gun case from New York asks the question, does New York's law requiring that applicants for unrestricted concealed carry licenses demonstrate a special need for self-defense, does that New York statute violate the Second Amendment? Sai, may I turn to you on that? Your thoughts about the Second Amendment, maybe perhaps fill us in on Justice Thomas's views on that. Does Are there any limitations that can be placed on Second Amendment rights to bear arms? And where do you see this case going?
Well, the last question is stay tuned, right? We're going to find out over the course of several cases what regulations are permissible. I mean, as you know, Barbara, and as you know, Sarah knows, the court decided several years ago that the Second Amendment right was a personal right, and they decided it applied both to the federal and state governments. And they, those were controversial cases in their own right. And now we're sort of seeing the aftershocks or after effects of those cases. And I didn't listen to the oral argument, but from the news accounts, I think seems likely that the court's going to find that the New York statute, which requires, as you said, a special cause to have a carry permit outside the home, is unconstitutional. And I think for people that don't believe that the Second Amendment, protects an individual right, this is just insult to injury, right? That they already think the court's wrong, and now they're extending the wrongfulness of those decisions. But for obviously for people who believe in a personal right to keep and bear arms, they're going to think that this unduly burdens it, right? That once you say there's an individual right, you need to apply the sort of doctrines you would apply with respect to other amendments, and that's certainly Justice Thomas's position. He does not believe that the Second Amendment right is a second-class right, and he's more willing to apply tests that make it more difficult for the federal and state governments to regulate guns. I suspect that he's something of an outlier on this question in the sense that he's probably to one extreme, but the court votes forms coalitions, and so he can be part of a majority coalition that protects individual rights even if he doesn't get everything he wants.
Before we take Al Pola's question from our audience about Justice Breyer's announced retirement, Sarah, let's maybe delve into just one more case for the time being, and that's the one involving God or religion. This comes from the state of Maine. The question the court is having to wrestle with this term is, does the Maine law that is the state of Maine's law, prohibiting students participating in an otherwise generally available student aid program from choosing to use their state aid to attend schools that provide religious or, quote, sectarian instruction, does that law from the state of Maine, that policy from the state of Maine, does that violate the religion clauses of the First Amendment or the Equal Protection Clause of the 14th Amendment?
Well, this case certainly follows a trend of increasing scrutiny on religious discrimination. And I predict that that will only continue with the recent confirmations of justices who are known to be very active in their religious communities. Currently, a majority of the court, 6 of the justices, practice Catholicism. So it's a very interesting issue. I'm going to cheat a little bit just by pivoting from religion back to guns.
Yes, feel free.
Because I wanted to commend, I thought Sai's comments were fascinating. I wanted to just commend for everyone's reading a really interesting amicus brief. There's some interesting bedfellows in this case. A group of prominent conservative lawyers and former government officials in Republican administrations, including Michael Ludig, former Fourth Circuit judge, filed a brief in support of the state of New York, saying that history, originalism, basing its theory on originalism, supports some regulation of loaded guns in public. Historical boundaries adhere in the Second Amendment's right to bear arms. Another thing I thought was really fascinating about this brief is that in addition to this very intellectual, kind of almost academic approach to originalist history, what the statutes were in the books when in the 1700s during the founders' time, also contains, some press release worthy, commonsensical appeals to the practical implications of this issue. One of the bullets in the headlines in the brief is restricting loaded guns in public places is a vital, historically rooted legislative option for minimizing gun violence on America's streets and in public places. So I was really kind of blown away when I read this amicus brief, particularly as someone when I was in the Clinton White House counsel's office, who used to have the gun control portfolio. And it was a very sad and sobering portfolio because there were so many school shootings that took place during that time. And I think we do have a mass epidemic of gun violence in this country. And it will be really interesting to see how the court comes out here. I very much agree with Sai's comments that it appears that, and this is evident in Justice Roberts' comments, that a fundamental right is a fundamental right is a fundamental right. If you don't have to get a permit to speak on a street corner, why should you have to get a permit to exercise your right to bear arms? But I think
thank you for that and for finding the amicus, the brief on that. That's fascinating, the friend of the court brief. We have a question. We have a couple other cases we may go back to if we have time, but this question by one of our audience members was asking about, this was our next topic to cover, about Justice Breyer, and that he was noting that there had been a push for Justice Breyer to retire so that President Biden can name a younger, and Al says, liberal judge. Now, Al also makes the point, he says, federal judges are required to retire by a certain age. That is actually incorrect. There is no retirement age for federal judges. They serve for what is called good behavior, which means they get to choose when they go off the bench, which is why we've had some of the great justices. Oliver Wendell Holmes served well into his 90s. Justice John Paul Stevens most recently served into his 90s. And so this concept of, the lower federal judges have a retirement age. That's not so. No retirement ages for any of the federal judges. But there has been some talk over the years about seeing if there could be a way perhaps to amend the Constitution to require a retirement age. And then there have also been issues about maybe packing the court. That is, could there be more seats added? That's one way that presidents have tried to pack the court if they can't do it the old-fashioned way. And most people know about FDR's court packing plan. But let's start with the present. That is Justice Breyer's retirement. Sarah, want to take a stab? Were you surprised at all that he decided to do so this term? And if not this term, were you surprised that he did so a bit earlier than most? Most will often wait till the end of the current term in which they're sitting to announce they're retiring.
I will confess I was a little surprised because I think it's hard. It's hard to give up such a wonderful occupational position. Certainly it was difficult for Justice Ginsburg, but I think it reflected one of the characteristics of Justice Breyer's jurisprudence over the years, which is that he is a major pragmatist. And, he brought that to bear on his decision-making, and I think it's reflected also in his decision to step down when he stepped down. I was very moved by the retirement announcement that he made, not in the Oval Office, but in the White House, where he invoked the Gettysburg Address. And he talked about how his wife had paid, I think, his grandchildren or his nieces and nephews some bit of money to memorize the Gettysburg Address. Because he was basically saying, this is an American experiment, our constitutional democracy. And it's up to the next generation. He talked about how much he loves speaking to high school students and college students, and last but not least, law students, about the fact that democracy is and the lastingness of democracy is not a given. It's still an experiment 250 years later, and that it's up to every generation to ensure that government by the people and for the people persists.
Sarah, you will remember this well. I will always have a soft spot in my heart for Justice Breyer because he started at the court the same week we did. In 1994, his inauguration was our first week as judicial fellows. And in fact, our office at the Supreme Court put on the inaugural ceremony at which the president comes up to the Hill and comes to the court and participates, at least from the audience, and then they have a really nice reception. And I can remember Ted Kennedy coming over from Congress because he had been a mentor to Justice Breyer. Justice Breyer had served with him on the Judiciary Committee. So I wondered your thoughts, having served as a clerk, about a retirement age for justices. Not that you would necessarily be advocating that for anyone in particular, but do you have a sense that there should be any changes in the number of seats on the court, or should there be a retirement age? Any thoughts about this commission that was put together of late to study the court and its membership?
Well, on the latter point, Barbara, that commission produced a very interesting 200-page report, very balanced and very nuanced, and not likely to be read by the president or anybody else but an academic. I think President Biden appointed the commission to bury the issue, and he has buried it. I don't think there's going to be any majority. There isn't a majority now, and there won't be to pack the court. So it's really an academic question at this point. I think if you're thinking about a retirement age, one has to wonder whether all three branches need a retirement age, right? Do we need, two 75-year-olds running for president? It seems like it's not a good idea in the abstract, even if you love one or both of them. And I say this as someone who understands that, I will be 75, and I'd like to think that I will be super sharp. But it's not obvious that the decision makers, the highest decision makers in the government, in the executive, legislative, or judicial branches, ought to be that age. There might be some reason to have a cutoff, knowing that you will be cutting off people who are still in their prime in order to avoid the possibility that people who aren't capable of handling the job won't serve. Having said all that, I hope Justice Thomas serves forever.
Well, I will point out that my mentor, Henry Abraham from the University of Virginia, who passed away 2 years ago this month at 98, he used to like to give the statistic that Supreme Court justices' longevity is second only to symphony orchestra conductors. Presuming that symphony orchestra conductors are also still pretty sharp at advanced ages, I'd like to think the justices are as well. We'll put aside Congress and the presidency for another conversation. Well, this moves us on to potential replacements for Justice Breyer. And Brian Craig, who is one of our professional researchers in the Presidential Oral History program here at the Miller Center, asked, do you think the president would nominate a politician? And he mentions precedents for that. William Howard Taft, Jimmy Burns, Earl Warren, to be a judge on the court. What are your thoughts, Sarah?
Well, first of all, I have to say I'm from the Betty White school of longevity. But so I too don't believe in any term limits for the Supreme Court. But I do think, the candidates on the short list, per the media accounts, tend to be younger, not too young, but sort of in the late 40s, mid 50s range, individuals who would serve on the court for a very long period of time. I do think I too long for a different type of background on the court. There's been a tendency over the years to elevate justices from the courts of appeals, and particularly the DC Circuit, the court on which Judge Ketanji Brown Jackson is currently serving, or state Supreme Courts like Leander Kruger. But I do think that particularly in these polarized times, and in the way we see this polarization sort of creeping into court language and decisions and that kind of thing, and oral argument, that it would be wonderful to have a unifying leader. Not, of course, I think Chief Justice Roberts actually does a very commendable job in that respect, but someone from a different walk of life would be refreshing.
Cy.
Oh, well, as a lawyer, I object to anybody not being a lawyer and being on the court. As far as politicians go, I think, I could see the desire to have that. I think it partly turns on what you think the job of a justice is. If you think the job is partly or largely political, well, why wouldn't you have someone who is a lifelong politician on the court? If you think it's more technical, then you could see why you'd want to have some lawyer who's steeped in doing, judicial things, right? Having served as a judge, interpreting statutes, interpreting constitutions. And of course, we've had people in the past who weren't a judge beforehand. The last person was Justice Kagan. She had been the Solicitor General, right, and had been an academic, and of course, academics make the best justices. So, I think President Biden will appoint a sitting judge, because I believe he'll believe that that's the safest thing to do, even if it might be interesting to appoint someone who's never been a judge and who is a politician.
Sarah, do I remember correctly? I know one of your duties as a judicial fellow was doing oral histories particularly of women on the federal bench. And do I remember correctly that you interviewed both Justice Ginsburg and Justice O'Connor
Yes.
for that project? Any thoughts to relate, particularly from Justice O'Connor, who had a political career? And in fact, she was a pioneer in her political career. She was the first woman majority leader of a state senate. Did she talk about that at all with you?
She did. We certainly plumbed the depths of her various experiences, including that experience before she became a justice. I think she's Exhibit A of the type of candidate who, because they've served in a political capacity, I'm talking about different walks of life, being not people who aren't lawyers, right, or potentially past judges, but people who understand the necessity, particularly in the legislative branch or in the executive branch, of achieving consensus. And that, I think, was that's the reason that Justice O'Connor became such an important swing vote. And perhaps one of the reasons, for example, we saw, in Casey, the joining together of 3 Republican justices to err on the side of upholding precedent in a very controversial case. So I do think, she was, I remember I had a little trouble with the tape recorder. Back in those days, we actually used tape recorders instead of iPhones to tape things. And if she was a perfectionist, and everything started right on time. And so she expressed a little bit of frustration about the fact that the technology of those days wasn't working correctly. But she talked about her days on the ranch, growing up in a completely different environment, what it was like to be in law school at Stanford with, one of the only women at the top of her class, what it was like to not be able to get a job in a law firm in Arizona. I mean, just incredibly wrenching experiences, both Justice O'Connor and Justice Ginsburg, but their attitude towards their own challenges as women in the profession was one of persistence, dogged courage, and never complaining about the challenges, but rather sort of picking oneself up by one's bootstraps and persisting.
Now, this concept of coming from different walks of life, something that's really on the front burner right now, aside from career diversity that we're speaking about, or the lack thereof, is religious diversity, racial diversity, ethnic diversity, gender diversity, and really going back to a piece that I just wrote for The Hill called "What Does It Mean to Have a Court That Looks Like America?" This concept of a president, probably all presidents want to have ideological kinfolk on the bench. So that's usually their first consideration. We always hope merit is right up there as well. We want meritorious justices on the U.S. Supreme Court. And of the 115 who served, I think we can say most of them were at that top category. But going back to George Washington, who wanted to represent certain states in order to be diverse, or as we got closer to the Civil War, have some regional diversity, that has also been a category of consideration for presidents, including for someone like Justice O'Connor. And I had the privilege of interviewing her for my dissertation, which was on the subject of religion, race, and gender in appointments. And I asked her about the role of gender, which was paramount for Ronald Reagan in naming her, in addition to which she was highly qualified. And he thought was a conservative, and she was a moderate conservative. But I asked her about gender in her appointment, and she said, first of all, why do you think you're here? So this was in about 1984. She'd only been on the Supreme Court for 3 years. And she was trying to say to me, you're a woman graduate student, and I accepted your offer to come and interview me. But then she added something I'll never forget. She said, we are all the sum total of our experiences. But she said, when I cross the threshold of the door of this court every day when I come to work and decide these cases, I try to leave that behind me. And I really do believe, maybe I'm naive, but I really do believe that justices attempt to do that. And we should also add that we've talked about a lot of the culture war cases and the hot button issues and the political cases, but so much of what the court decides is not along those polarized, divisive lines. There are cases that don't divide naturally along those lines. And we should also point out that in the last 20 years or so, the statistics show that cases decided unanimously range anywhere from about a third of the docket per term up to about 2/3 of the docket. So it's not as fraught as some would indicate. We also have some more questions coming in. This is two viewers ask today. Are there possible ethics reforms for the court in relation to the financial holdings and family dealings of justices? Sai, want to field that one?
Well, Congress has laws that regulate what when judges have to recuse and when justices have to recuse. But I think for the Supreme Court in particular, there's not thought to be an effective mechanism for enforcing those rules. And I'm not sure. I've never looked into it, but I'm not sure how there would be. Are you going to create a separate body to enforce those rules vis-a-vis the court and have some third party tell a justice that he or she needs to recuse? Barring that, the justices will be deciding for themselves whether or not they need to recuse, either collectively or individually, and will still have the same sort of issues that some people believe we have today.
Sarah, you've been on the federal bench. Your memories, first of all, did you have to relate what your financial holdings were leading up to your naming to the bench? And tell us a little bit too about your Article I judgeship. What's the difference between an Article I judge and an Article III judge?
So first of all, yes, on the financial disclosure question, every appointee of any type, including judges, has to comply with the Ethics in Government Act by submitting a financial disclosure form, which is scrutinized by both the Senate staff and the White House staff. And there is an ethics office in the Administrative Office of U.S. Courts. One of our other Supreme Court fellows, Bob Dealing, worked in that office. So they get the judges have available to them an excellent resource with which to consult on ethical issues. I would just say self-governing. The judiciary is sometimes criticized for self-governing rather than taking the position that certain statutes like Title VII apply to the court. And I think self-governance is as strong as it is responsibly administered. An Article I judge does not sit for life. It is a creature of legislation. In the old days, cases were referred by the legislature to what was called the Claims Court, and the Court of Federal Claims has exclusive jurisdiction over money damages claims against the government, whether rooted in Constitution, like takings cases, or contract or statutes. It was a fascinating experience. I really enjoyed my time when I was there. One of the most interesting questions that came up during my tenure, I was a recess appointee, so I only served 2 years, was when I was recess appointed by President Clinton when President Bush came into office, and there were 7 vacancies, and typically a series of nominees who would go up with one from the opposing party. as a consensus package, President Bush nominated someone into my spot. And so the interesting and novel constitutional question came up: if that nominee were confirmed, who would have the right to the seat? As it turned out to be not an issue that ever needed to be decided, because with Senator Jeffords' switch to becoming an independent, the Democrats took back the majority in the Senate, and my recess appointment was safe for the duration of my term. But really interesting opportunity to grapple with some fascinating issues. I always liked the cases where the briefs on both sides were top notch, and there were compelling arguments on both sides. Those were my favorite cases.
Well, let's talk a little bit too about the lower federal courts. That is the Article III courts, the trial courts, the U.S. district courts, and then the courts of appeals, because Cy, you served on as a clerk on a U.S. Court of Appeals. Sarah, you served as a clerk for a U.S. district judge. And while, again, the average person in the public sphere is just going to be thinking in terms of the U.S. Supreme Court, that docket number has fallen precipitously. I remember in graduate school, there were about 160 cases back in the 80s that were decided per year by the Supreme Court. That has fallen to way below 100, in part because they now have virtually complete discretion over their docket. But the thousands of cases that swirl through our trial courts and then the middle level of the courts of appeals, the so-called circuit courts, obviously that's where the decisions get made finally, because that's where the majority of cases are. So tell us a little bit about what those courts do and how they fit into the federal judiciary and why we should care about them. Cy, your experience in the circuit court clerkship?
Well, I mean, Barbara, everything you said is exactly right. Most cases start in the district court and there's a trial, and then the losing party might appeal. And if they appeal, it goes to the circuit court, and there may or may not be oral argument in the circuit court. Sometimes they'll just decide it, on the briefs. And a very small portion of all those cases seek Supreme Court review. And as you said, an even smaller portion of that actually get any review in the Supreme Court. So most legal questions that get to court are decided by the trial courts and the circuit courts. And because the Supreme Court has limited attention span and limited time and limited resources, it just doesn't sit in review of all these decisions. So more specifically, the Supreme Court won't take a case just because it's convinced that the lower court was wrong. Right, that they'll just decide that that's, quote, mere error correction. Another way of putting that is, even if you're right that the lower court made a mistake, we can't expend our limited resources overturning every mistake of every circuit or trial court. So who's sitting on the federal bench in the district and circuit courts matters quite a bit. And there's no doubt about that.
Right. And Sarah, one of your duties, as I recall from when you were in the White House counsel's office, was to work on appointments to those lower courts. And do I remember correctly that now Justice Sotomayor was one of the appointments that you worked on? Was it for her to the district court or Court of Appeals?
It was through the Second Circuit, the U.S. Court of Appeals for the Second Circuit. And it was a fairly contentious nomination and confirmation process, because she was appointed to the Southern District of New York, the federal trial bench, by either President Bush or Reagan. And she was going to be elevated to the Second Circuit by President Clinton, a Democrat, with the almost clear knowledge of hope, probably be a better word, but that there could be a potential Supreme Court vacancy. And so she got a lot of scrutiny for the Second Circuit, ultimately got through, but a really, really microscopic look at her decisions as a Second Circuit judge. I can tell you this now because it's all in the presidential library, but Chuck Ruff, then the White House counsel, turned out to be incorrect tip that Justice Stevens might retire. So for 2 or 3 weeks, we were in a complete tailspin, 24/7, vetting, on paper, a potential candidate for the person who might become the first Hispanic justice on the Supreme Court. And so it's very reminiscent of what is going on right now. Of course, there's an actual vacancy, but a one that would be historic in terms of having a Black woman appointed to the Supreme Court for the first time in American history.
Yes, it does look like that will happen. We have a question actually from a couple of our viewers today, and we touched on it just a little bit. Sarah, I think you mentioned Chief Justice John Roberts' leadership of the court. Maybe we can park on that just for a few of our remaining minutes, because for those of us who study the Supreme Court, court eras are always known by the Chief Justice who sat during that time. So we talk about the Warren Court and the Rehnquist Court and now the Roberts Court. And I noticed this week, for example, in a case that was apparently they have accepted and will hear an oral argument, I think, for next term, the Alabama gerrymandering case, but that they issued a ruling or an order about the lower court's ruling, that Chief Justice Roberts was in the minority with the liberals this time around. He was in the minority in the dissenting view. So your thoughts about, first of all, in terms of age, he is past now the normal retirement age of 65. I'm not suggesting that he's thinking about retirement, but just noting that we were talking about age, and he is now past that age of 65, seems in very good shape. And so I presume will stay a lot longer. But certainly when he came into that Chief Justice chair, the center chair, the first among equals, as it is known, he talked about wanting to try to have as many, if not unanimous cases, avoiding as many 5-4 cases as he could, but because he said, referring to the court's legitimacy, with how we started this conversation today, he thought, looking back over the sweep of history, it's better for the court's legitimacy and authority not to have these polarized, particularly seemingly partisan splits, and that he even asked for an aide to go to Richmond to get the robe of the great Chief Justice, our fourth Chief Justice, John Marshall, so that he could wear that robe for his investiture, because Chief Justice John Marshall was known as the great aggregator of the court and handing down many unanimous decisions. So thoughts about the leadership of Chief Justice John Roberts and how it's evolved and where you think it might be going?
Yeah, I think this Alabama case that you just referenced, which came up in an unusual way, wasn't on the merits, but on sort of an emergency stay, is an example. He wrote a separate opinion, but he said basically joining the vote with the liberal justices too soon for us to be deciding this case. We need to have sort of full briefing before we get in, and oral argument before we get into the merits. Kagan was quite critical of the so-called shadow docket, which we don't really have time to discuss or debate here, maybe another time. But I think he cares very much about the legacy of the court. I think he has been a unifying force. The decision on the Affordable Care Act is probably the best historical example to date.
Yes, and again, since you were a clerk at the court, you would have seen firsthand his leadership. What did you make of it? How would you describe it?
Well, Barbara, I was there well before the chief was appointed. I was there when it was Chief Justice Rehnquist. So I've never had the pleasure of meeting the Chief Justice.
We called him the old chief after Roberts came along.
That's right.
And he was, certainly Rehnquist, even though he was very conservative, and when he was an associate justice, used to be called the Lone Ranger by his clerks because he was often in solo dissent. But he was very well liked. And you must have had that sense then in serving with the Rehnquist court, that he was very well liked by all of the justices and was viewed as affable. I didn't always see that, I must say, in my dealings with him, but a good and great leader of the court. And my sense is that the Chief Justice Roberts is viewed that way too. But anyway, back to you, Cy, and you get the last word.
I think the chief is very much trying to preserve the court's institutional capital by doing as much as he can to get consensus on opinions. And of course, the other justices sometimes disagree, and that's what's causing him heartache and headaches.
Well, I think that not only did we cover a lot of ground in just an hour, we thank all of you who are in our audience today for participating in our poll, for submitting your questions. This session is archived and will be archived on the Miller Center website, so feel free to go back and look again or share it with your friends and family. But also, I just have to thank my dear friends and colleagues, Sarah and Cy, because not only, as I promised you, are they so experienced in this realm and so knowledgeable, but they model what the Miller Center stands for, and that is civil dialogue, and even not even having to agree to disagree, but rather to find the commonalities, even if we have some differences of opinion on occasion. So thank you, Sarah. Thank you, Cy. Again, thanks to all the folks at the Miller Center make this possible. And we look to see you again at our next forum.